As an employer, whenever you get a demand for employee records, you know that there's an attorney investigating your business practices, your business, and what they're trying to do is get a recovery from you. So the first sign of the fact that an attorney is looking to be able to make a claim against you on behalf of an ex-employee is the employment records request. This is why it's so critical that you get somebody to help you as soon as possible and as soon as you receive this request. Because the reality is it's only going to escalate from there, and you want to make sure that you have somebody helping you who's gone through this process time and time again. My office has represented employers in numerous cases, both in pre-litigation, meaning before a lawsuit has been filed, and after. In a number of the pre-litigation claims where there's a demand for employment records, we've been able to get exceptional results where the other side just backs away. Now, of course, we can't guarantee that this happens, but I can guarantee you and promise you that we have gotten this result multiple times, numerous times for our clients, because the way we do it, we look at a employee's records, we look at the employment file, and we help the client, the employer, plan ahead. So for example, one case we had was a client had a very successful tour operations business in Hollywood, California, and he got a demand from a popular employee demand mill. Said differently, he got a demand from an employee side mill type law firm where they churn out demands. Ultimately, because we had represented clients against this law firm before, what we did was we sent back a strongly worded reply along with the employee's records and showed them why it made absolutely no sense for them to try to pursue this and how it was going to be a problematic and challenging case for them. And ultimately, they just backed away. They didn't pursue a claim. And we've had other cases where we have settled cases for pennies on the dollar. For example, we had another client who had terminated an employee after the employee had made a complaint about an injury. Now, that employee was underperforming, so they had planned on firing this employee anyways, but unfortunately, they didn't check with employment counsel about the best timing to be able to fire this employee. So when they fired her, she had already made a claim for injuries on the work site. Now, of course, my client believed that these claims were fraudulent and false, but the reality was that these needed to be considered before they terminated her. But they terminated her, and of course, they got an employment demand, not only for the full file, but also subsequently a demand for multiple six figures in terms of a potential settlement. Now look, because California's laws are so favorable to employees, the client needed to be aware of the potential risks, and they wanted to make sure that they got the bomb defused and they got the case resolved in pre-litigation. So ultimately, even though this case realistically would have been worth multiple six figures or potentially even a seven-figure resolution if the case had been litigated or went to trial, we got the case resolved for less than $10,000. So it was a great outcome, but we were able to do that because the client trusted us, acted quickly and decisively in hiring me and my law firm to help them. Now look, I can't guarantee you that we can get you the exact same results that we have gotten clients time and time again, but what I can guarantee and promise you is that we go to bat for our clients. We take the time to understand them and their business. So if you have questions about this, please reach out to me and my team because we're happy to help you.